Ladies and gentlemen, and all our distinguished speakers, good morning. This session is one word and one internet, and we'll the topic of TWIGF 2020 is one word and one internet. And our session is one internet in several jurisdictions in one word. You can compare these two topics, and you can find that there's a question mark put in one word and one internet. And why we put the question mark there, that is, I think that is because there's so many jurisdictions in one word. And different jurisdictions makes different law and regulations. That makes it difficult to keep one internet. And today we are so glad that we have such kind of chance to get together to discuss this topic. And before we our distinguished guests start their presentation, I would like to make a brief introduction to our topic. Would you please? My slides. Oh, already there, okay. Okay, and I would like to introduce what we are going to discuss and what kind of point of view that we could present. The key point of our topic is about the jurisdiction. Jurisdictions make people in different places have a different kind of different way of life. If you are the people from nation A go to the place of nation B, there's a border regulation. Even the goods and the money, like that we have anti-money laundering regulations. But interestingly, that if we get the data from other country, that it seems that there's no such border regulations. When you browse the website in other country, you will not find any regulations when you are browsing on the internet. It seems that the internet is born to be without the borders. But is it really true? Actually, it is not necessary to be so. I'll share you one story about the initial top-level domain name. The drafted memorandum of initial top-level domain name, there are several top-level domain names. Only .arpa, .ddn, .gov, .cor, .pub. There's no country or border idea involves. I'm sorry, here's one wrong spelling. And what is the response of average to such initial top-level domain name? There's one man who called Mark Horton. He said that without exception, they, especially the people outside the United States, all want the top-level domain names to be based on geography and international boundaries. And this story is in Mr. Muller's books, Ruling the Root. And I'm so happy that he's here today. And maybe he can say more about this story. And we can see that the response from the average people, they think, at that time, they will think the internet should be, there should some something like country borders in the internet. So just imagine if there's a word without GTLD and plus immigration control on the data, internet data flow, and it is not like the internet today we used now. But luckily, at the final version of RFC 920, it was drafted by John Postel in 1984, October. So finally, the initial top-level domain name are 3 kinds. The first one is temporary, is .arpa. The second is categories, .gov, .com, and .mil, and .org. And there's also CCTLD, and it was borrowed from the ISO 3166. So today we have the general GTLD and the CCTLDs, so we can keep the internet in one. But there's still some way to hampers, or it could break down the one internet. The first one is Great Wall. To set up a Great Wall on the internet to filter in all the content. Some countries does so. And the second one is disconnection. If some countries think that the internet is threaten their nation's safety, maybe they will disconnect the internet. And I remember that the Supreme Court in India, it said that maybe it is against the human rights protection. So today we also have an expert on international human rights, Professor Xu. And the next is law and the regulations with extraterritorial effect. It's a classical kind that could help the one internet, because different law and different regulations all apply on one internet. There may be some conflict on it. And the next, maybe the war. If we start a war and the internet maybe break down. And today we also have an expert on law of war, Professor Xu. Professor Tian. So let me explain why the law and regulation could make confliction in the internet. For example, like the ICANN WHOIS policy. Now all the ICANN community discuss these topics. And the GDPR in Europe, they think the past ICANN WHOIS policy is against the GDPR because people provide their personal data without a true consent. But in the US, here's the Assistant Secretary of Department of Commerce, David said that if alternative solutions such as if the ICANN community cannot find a solution for the conflicts for GDPR and WHOIS policy, the alternative solutions such as call for domestic legislation. It means that the United States could make its own legislation for the WHOIS policy. Well, he said that the domestic legislation will only intensify and be considered. And in addition, like China, they govern the internet not as the way we used to. they have a lot of law and regulations for the internet, like the Internet Domain Name Management Regulation. In this regulation, Article 3rd, it provides that whose service should be provided by registry. So you can see the conflict here. So what the ICANN community should go. So according to the discussion above, I would like to introduce our panelists and their possible perspective. And the first panelist is Milton Muller. It's been a little hesitation. I have to confess, I'm his fan. In my PhD dissertation, I cite a lot of his books. Today I bring those books here. Okay. I hope I can have his signature today. And he's the expert of experts in internet governance. So I'm so happy that today he can join us in the internet. And the next one is William Xu. He's the expert of international human rights. And he's also my classmate when I in Soochow University, pursuing my master's degree. I think that he can share a lot of international human rights law and connect it to the internet governance. And the third one is Professor Tian Liping. He's the professor from the University of Defense. I think that he's the only very few expert in Taiwan who studied in law of war. As everybody knows, that Taiwan has a very, very strange status in the international relationship. So there's only very few professors who study on this field. And we are also happy to have Professor Tian here with us. And the last one is Nicole Chen. He's the former chairwoman of NCC, National Communication Committee. And I believe she has the expertise of the public policy because of his experience and his position in our government. And she also very familiar with the internet industry. So today, we are so happy to have them to be with us. So, shall we begin? Okay, so the first one, I would like to invite Professor Muller to make your own presentation.
Hello, everybody. Yes, I am absolutely delighted to be speaking before the Taiwan Internet Governance Forum. I am really would wish to be in Taiwan itself, of course. I was invited there, and of course, because of the coronavirus, we had to cancel all the physical meetings. But I understand that you're doing very well with the control of the virus, so I should have come anyway, right? Then I would have to spend 2 weeks in quarantine, maybe, but that would be okay. I'd like to spend 2 weeks in Taipei or Taiwan. I think Taiwan is really at the center of the world attention now with respect to the future of the internet, because it's kind of standing in between the two world powers that are conflicting over internet governance, which is the United States and mainland China. And that's another reason why, what you do there is extremely important, because it shows that there can be a democratic and free China. Now, Henry Tsai hit on, I'm very pleased with the way he has introduced the topic, because he's talked about what is really the fundamental issue of internet governance, and has been the fundamental issue for many years, and that is the relationship between the global internet and territorial sovereignty, or what he calls jurisdiction. I prefer to focus on sovereignty because it's a more fundamental concept that underlies jurisdiction. And I take a historical approach to the emergence of sovereignty to try to understand what it means better. And I have been arguing now for some time that cyberspace is a sovereignty-free zone, that there is no sovereignty in cyberspace. This doesn't mean that there's no borders in cyberspace. The borders are technical. The borders are based on boundaries between different managed networks. But cyberspace is composed of the interconnections created by the Internet Protocol. That is to say, TCP and IP at layers 3 and 4 of the OSI stack. That we create cyberspace by everybody using these protocols and by using this consistent naming and numbering scheme. And those resources in that space is borderless and global. Now, it's very interesting. He brings up this issue of the early top-level domain discussions. And I think it is very interesting. It indicates that we did end up with kind of a mixed world in which we have these global top-level domains like .com, .net. And then we have a bunch of what we call country code top-level domains, such as .tw or .us or .de for Germany. But it's important to consider why, there was a suggestion that people outside the United States wanted to have country codes. But it's important to remember why that made people nervous back then in the early 1980s. And that was because you had a bunch of computer scientists who were basically running a data communication network, and they did not want to be put into the position of deciding who was a country. For example, if we had decided to allow the United Nations to assign country codes so that the internet would be bordered around national jurisdictions, you can be pretty clear that Taiwan would not have .tw, right? Because some very powerful governments would not recognize it as a national state. And that would be one of maybe dozens of other contested definitions of what is a country. And so they had a very explicit discussion of that in the early days. And they said, I don't want to be the person deciding who gets recognized as a country, as a nation in the world. So they chose this standard, the ISO 3166 standard, which had a list of 2-letter country codes, but mainly they are territorial codes. They are not actual sovereign countries. For example, there's all kinds of 2-letter codes in there, like .io for the Indian Ocean. There's 2-letter codes for various islands around Europe and Australia, which are not really sovereign countries. So we ended up with this kind of strange mixed world in which some of our top-level domains stood for territories, and some of them stood for global categories like .com. But even if you think, country codes are good and interesting, it still doesn't really solve the problem of cyberspace governance, because for these country codes to exist, they have to be entered into a globally applicable, globally accepted root, the root of the domain name system. And that root, well, who does that belong to? Should it belong to one country, or is it a globally shared resource? The reason we created ICANN as a non-governmental entity, and the reason we eventually eliminated the US government's control over ICANN, was so that the domain name system root would indeed be an international, independent, and neutral administrative entity that would be shared and used by all nations on equal terms. So, you know, we don't really have countries in top-level domains. We have names of countries sometimes, or we have abbreviations for country codes, but the borders of those, you know, who can participate in those top-level domains could be anybody. Some of them are totally global, like .cc, and some of them are restricted to country residents, although that's actually not all that common. So I think we need to understand the internet and cyberspace as a shared global commons. It doesn't mean communism. It means that it's a space that is not owned and controlled by any one country. It's like the ocean, the high seas, which we formally recognize in treaty as a global commons with no sovereignty, or like outer space, where we have, again, a formal treaty that says there is no sovereignty in outer space. And it's been a very good thing for the internet that they created, really from the beginning, it was this global commons, which was not owned by any nation state. And that allowed all of this information to flow across borders and create all this freedom of expression. And that really disrupted lots of controls and forms of censorship. And of course, it created some problems too, problems that we are trying to control. But I think we can do that using global governance entities, non-governmental global governance entities, such as ICANN, or the platform rules and content moderation policies can be serving as the alternative form of governance. And there could be new forms of alternative governance that we can invent that would solve some of the problems that we face in cyberspace. So my concern is that if we think of cyberspace as a territory where governments have try to control their jurisdiction, we have governments are going to be competing for control of the internet. And there's only two things really that can happen when that starts to take effect. One is what I call the digital island, where governments basically cut themselves off from the rest of the world in order to maintain control over their information space. And the other is to have one global cyber sovereign, that is to say, a world government that is so big and so powerful that it can control everybody and everything that happens in cyberspace. And I don't think either one of those options is a very good one. I think what we want is this kind of loose and cooperative, networked form of governance that we have now, with non-governmental entities handling names and numbers, with non-governmental open entities handling standards. So I see my face has been covered up on the screen, so I think maybe they're signaling that it's time for me to stop and let somebody else talk. So I will do that now.
Okay, thank you, Professor Muller. From his remark, I think people in Taiwan should appreciate the scientists in the early age that take ISO standard for CCTLD, so that we can have our own .tw. And it seems that Professor Muller think that internet is common property of the whole human society. But I have several questions to ask him later. Okay. Now, our next panelist will be Professor Xu. Okay.
Thank you, Henry Tsai, for inviting me to join this forum. And Good morning to our distinguished panelists and all the special guests today. And good morning to, maybe good evening to Professor Muller, right? I'm very glad to be here today. When I was invited by Harry, I thought that should I accept this invitation, being tortured by discussing those topics that I'm not familiar with, such as cyber law. I'm not an expert on this field, but after accept this invitation, I found that it is a quite interesting area. I think I should spend more effort to develop or do some research on it from the perspective of human rights law. So today, my short talk is entitled in the human rights responsibility of cyber operation in the context of international law. Beginning with, can I have the, okay. In the introductory remarks, I can give you some short introduction to some cases relating to cyber operation and what problem or issues it raised in the context of international law. And in the beginning, I'm quite, maybe most of you have acknowledged that in the early 2007, there was an alleged attack to Estonia. The attack was raised from a political difference between the Estonian and Russia over the interpretation of relocation of a Bosnian soldier of Tallinn. This led to a catastrophic cyber attack target at the Estonian organization, including governmental ones and non-governmental, such as banks, government agencies, schools, newspapers, and caused many damage. And of course, a lot of inconvenience to the daily life of people in Estonia. There are several cases. Maybe Professor Chen will give up. Where should I point? It's out of power. Okay. Where should I point? There's another alleged attack, maybe from Russia to Ossetia in 2008. There's another famous one, the Starnex 2010. It was reported by the New York Times that it said that the the U.S. and Israel has developed a Starnex computer worm, and it was used to attack the Iranian nuclear enrichment facilities. And that alleged attack damaged seriously to the project of Iranian to develop their nuclear weapons. And there is the latest one is the Ukrainian-Russian conflict happened in 2014. Yeah, sure. Thank you. And this, it is reported by the media that during the Ukraine and Russia conflict, there were significant numbers of hacking and malware attacks the private sector in Ukraine. The pro-Russian hacker group, such as Cyberspace, has assumed its responsibility for this cyber operation against Nato, and the veto counting system for Ukraine election, and the mobile device within the U.S. Vice President's election during a visit to Ukraine. And we can also, as we can just see that there was a U.S. presidential election just finished. In the last presidential election in the U.S., it was alleged there were a lot of cyber attacks toward the media and governmental agencies' website. Of course, as Professor Muller just mentioned, that there's tension between Taiwan and China nowadays. And yeah, there are regularly and many cyber attacks or operation took place in Taiwan, and it is discovered many of them are rooted from China. So yeah, maybe as Professor Muller just said, Taiwan is good at controlling the coronavirus, but we are not, maybe not very good at controlling the virus from the cyberspace, especially from the other side of the cross rate. Yeah, so those cases really draw a lot of attention for me to think about whether there are any international law governing the cyberspace. In a brief answer, there is no current multilateral convention such as Outer Space Treaty, as Professor Muller just mentioned, governing the cyberspace in international law. It is also difficult to identify any practice repeated over time that would count as customary law applicable to this space. Nor has any specific case law emerged in the area of cyberspace. There are a few specialized conventions adopted in the area of cyber. For example, the Council of Europe adopted 2 conventions relating on this in the year of 1981 and 2001. I also share the idea of Professor Muller that cyberspace has the nature of global commons. But unlike other global commons, such as outer space and the high sea, which are very tangible, cyberspace is entirely artificial, conceptualized and manufactured by human being. Except for its physical infrastructure and facilities, all that belongs to cyberspace is entirely intangible. It is also changeable, since within it, any program, tool, or user can change its location, its function, and even identity. And another peculiar cyberspace centered around the question is accessibility. So we say that cyberspace has become truly universal. Okay, next one. Next slide, please. So yes. So when searching whether there are some related law in international stage regarding cyberspace, I can find there are some development happening nowadays in the international organizations, such as we know that associated with the IRC International Law Commission, there is a special group has been established, that is the UN Group of Governmental Experts on Development in the fields of information and telecommunication in the context of international security. Totally, there were 5 meetings held before. But totally speaking, most of those 5 conferences, except the one took place in the year of 2012, most of them cannot reach real consensus, except the third one. The third conference reached a consensus. They affirmed that the applicability of international law to cyberspace. There are still some decent rules in international law related to cyber operation or cyber warfare. But although they have very little contribution to developing the so-called cyberspace law in international organization, but there are still some implications I will explain to you later. But the major criticism invited by this special expert group is that the lack of representative. Maybe totally there are only 38 states participate in this conference out of the 193 members of the UN. But this conference has helped to identify the limits and possible loophole in the international law. The second one, okay. Okay. So there is another development happening in Europe, triggered by Nato, as most of us are very familiar with the major contribution of this conference. That is the Nato Cooperative Cyber Defense Center of Excellence. The major achievement of this activity result in two manual of Tallinn. Yeah. The first Tallinn in 2013 and the second one in 2017. The major purpose is to develop or find out whether there are some decent rules to regulate cyber warfare and cyber operation. And in the same situation, the results of this conference, although it is very significant, but it invites the same criticism as the conference took place in the UN, that is the lack of representativeness. The major participant of the meeting drafting Tallinn manual are experts from the cyber law, international law, and some other relevant fields. And the representative or delegation of nation, they do not participate very in a very substantive way. So we need to find out what's the nature of what is the nature of the legal nature of Tallinn Manual and the result of the UN conference? And that's their report. The nature of these three instruments, they are not in the form of treaty, which is signature by nation. So in a sense, we can conclude that they are not any form of international law which bind nation states or international organizations. Okay, next slide, please. But so as I just mentioned, there are still some decent international get involved. They will exist in three forms: international convention, customary international law, and general principle of law. And the direct source of law are the judicial decision and teachings of highly qualified international scholars. So we can say that the instrument of Tallinn Manual, they are only qualified to be the subsidiaries as teachings or contribution of scholars. Okay, next slide, please. But we can find that there are some important rules in the form of international treaty. That is the UN Charter, especially Article 2, Paragraph 4, and Article 55 and 56. In Article 56, it provides that the member of the UN has the obligation to fulfill the purpose provided by Article 55, that's to respect and protect fundamental freedom and human rights. So fulfilling and protecting the human rights standard established by the UN is a major obligation of the UN member. And we can see that there are many human rights conventions made by the UN and open to the signature of its member. Yeah. Okay, next slide, please. So as there are many human rights conventions exist, we come to the international human rights obligation of cyber operation. We have to deal with the subject of this relation, human rights relation. Typically, the human rights obligator in this law is the nation state or government. and the right holder normally are individuals. But in the scenario of cyberspace, which cyber operation or cyber war take place, individual or commercial entities plays a relative different role as they used to be in human rights relations. Because some cyber operations such as hack may triggered by an individual hacker. Yeah. So as for state, it is naturally to be an obliger of human rights law. But for what about the individual persons or business sectors? Next slide, please. Yeah. According to the draft article made by the ILC regarding the responsibility of state for international wrongful acts, we can find out that no matter an individual person or a commercial entity, if he or it is empowered by law, exercise the element of governmental authority, or the person is in fact acting on the instruction or under the direction or control of a state, the action or operation can be counted as an action of a state. So in this sense, that hacker individual or the commercial entity trigger the cyber operation cause damage to another country or citizen may have human rights responsibilities. Next slide, please. But there's another inspiring document made by the Committee on Economic, Social, and Cultural Rights. That's the General Comment number 24. It was made in 2017. It provides that, briefly speaking, it imposed another obligation to the contracting party regarding the obligation in the context of business activity. That's the extraterritorial obligation. Regarding the operate sector and economic, social, and cultural rights, the committee restated that states' parties' obligation under the covenant did not stop at their territorial boundaries. State parties were required to take the steps necessary to prevent human rights violation aboard by a corporation domiciled in the territory or its jurisdiction. Okay, that means that even those individual hacker or business entity conducting cyber operation which cause human rights violation in other country, and they did that on their own initiative, their mother country, who are the contracting party of the UN Human Rights Convention, they are obliged to stop or protect and fulfill the human rights standard made by this convention. So in a brief conclusion that, cyberspace has become has become universe. There is still no multilateral convention governing the cyberspace, but the general and universal nature of international human rights standards built by the UN may make this standard eligible to play a role of providing a decent or minimum guidance rules regulating cyberspace-related activities. So that's my brief conclusion and presentation, and I welcome your comments and questions later. Thank you, everyone.
Thank you, Professor Xu. One of my purposes to invite Professor Xu and Professor Tian is to include more people to internet governance community. I think that I'm successful to do so for this time. I'm so happy that there's any research done by Professor Xu, and he also raised several important issues on the cyberspace. The first one is the representativeness, and the second one, he also raised the responsibility triggered by the individuals who hack the internet. I think those issues are very important. And the next, let's go to the most serious about war. Yeah.
It's my pleasure to be here to deliver some of my observations regarding some areas that few people will take notice about this area. It's about the law of war. So my note will, from the perspective of the state cyber operations, and from the perspective of you said balloon, which is how to find the justification for state to use the force in the internet. I think the human beings have been exploring the space on the Earth for thousands of years. The first space is maritime space. So human beings explore and develop the sources, living sources, or any nature sources from the sea for thousands of years. So when the state take part as players in the exploring maritime space, there are two arguments. One is marine clause, the other is mare liberum. Mare clause means the state can claim sovereignty over the seas. Mare liberum argues that the state cannot limit any space, put any part of the sea under their sovereignty. So to mare liberum, the sea is unlimited. Every state can have unlimited right on the sea. Therefore, when the times come to 1982 UNCLOS, United Nations Convention for Law of the Sea, there are provisions prescribe how state should use high seas. So the UNCLOS prescribe that there are freedoms of navigations, freedom of overflight on the high seas. And the high seas shall be reserved for a peaceful purpose. And there is no state may validity propose any subject, any part of the seas under their subject. And then there is a part of a sea called Exclusive Economic Zone, EEZ. On that part of the sea, state can have sovereignty right to living sources. And the other part of the sea is a territorial sea. In that part, the state can have innocent passage to other states' territorial sea. Next slide. And human beings also have been exploring the airspace, I think, for hundreds of years. So it is the same as when human beings start to explore the sea. There are two arguments. One is the air clause, the other is the air liberum. It is the same background that people or scholars or states argue that this air should be circulated by the human beings. There is no limited, or there should be some space in the air should be reserved to state sovereignty, so that the state can extend or claim their exclusive and absolute sovereignty. So, but so far there is only one international treaty, which is 1944 Convention on International Civil Aviation. People always call it a Chicago Convention. In that convention, the main purpose for that convention is to regulate air transportation and safety, and claim again, restate again that the state have exclusive sovereignty in the territorial airspace. And most importantly is that convention does not want to regulate state aircraft. That means that convention does not have any jurisdiction over state act. They only have jurisdictions over civilian act in the air. So what about cyberspace? What should we think about cyberspace? How should we try to regulate any activities either by the civilian or either by state in the cyberspace? Should we make it analogous as to the sea, or should we analogous it as the regulation in the air? But the cyberspace is very different. It's artificial, it's virtual. But any activities in the cyberspace is much, much faster than any activities in the air or on the sea. So it is a great threat, much great threat to the international stability and to the sovereignty of any state. So people and the scholars begin to think that what kind of the law should we apply to the cyberspace, to those activities, especially state act. And not to mention that recently we have the international community begin to realize there is another actor called non-state actors, terrorist group. That's another part of the issues. So the question here from my perspective is, can we apply the existing laws to those cyber activities, cyber operations, or cyber attacks initiated by states? Next, please. However, it's a pity that so far, I think the internet was invented by the US Army in the 1960s, maybe. But so far, after 4 decades, there is only one convention, which is 2000, sorry, that should be 2004 or 2001, a convention on cybercrime. It was initiated, proposed by the EU, European Union, and it is the first international treaty. However, it is only focused only on crime committed via internet and other computer network. It's dealing with particularly with infringement of copyright, computer-related fraud, child pornography, and violations of network security. And the main object is to pursue a common criminal policy aimed at the protection of society against cybercrime. Rather, the state act. It's not about cyber warfare, cyber attacks, cyber operation by the military. It is only to foster international cooperation, but it's on crime. Next, please. So, time to the 2013 and 2017, there are 2 publications. One is Tallinn Manual. People maybe call it Tallinn Manual 1.0. The other is Tallinn Manual 2.0. So they are written by a group of international legal experts, and they are affiliated with NATO. However, those experts claim that they are independent from NATO. But when we find the list of the experts, we can find most of them from West country, those power countries, from United States, from the military of the United States. The cyber commander is one of the experts within that list. And it is an expression of opinions of a group of experts, and it's not intended to make any laws. And in the preamble of that, these 2 manual, experts claim that it's a non-binding document. And their conclusion is that most of the existing law can apply to cyber warfare. And it is intended to, as an objective restatement of lex late, that means existing law. And those 2 manuals address only state responsibility rather than individual responsibility. Like I have mentioned, the 2001 Convention on Cyber War Crime proposed by EU. And the most importantly is you can find, compare these two legal documents, where you can find a telemenu focus on mens rea. The mens rea is hostile, not malicious, not just malicious. And the excess res means the act. It focuses on conduct of hostility, which means the means and the method of armed conflict rather than crimes. It's not crime. Next, please. So when we talk about cyber activities from the perspective of militaries, not from the perspective of crime policy or law enforcement, we can find there are many terms. It is maybe called cyber operation, it may be called cyber attacks, or even cyber warfare. But we can find the definition, but there is no consensus. First, I have to say there is no consensus among states, among academic world. So a cyber operation, according to Telemenu 2.0, means the employment of a cyber capability to achieve objectives in or through cyberspace. And the ICRC, International Committee of Red Cross, their opinion is that cyber operations against or via a computer or a computer system through a data system aiming to infiltrate a system and collect, export, destroy, change, or encrypt data, or to trigger, alter, or otherwise manipulate process controlled by the infiltrated computer system. Next, please. And there is another term called cyber attack. According to Telemenu 2.0, Rule 19.2, it defined cyber attack as it's a kind of cyber operation, and either offensive or defense. And it is reasonably expect to cause injury or death to persons or damage to destruction of objectives. And attacks, according to Geneva Convention Protocol Additional Article 49, attacks means an act of violence against the adversary, whether in offense or defense. So from these two terms, cyber operations, cyber attack, we find cyber attack try to define an act by the states or any armed group during the armed conflict. Use the means and method as a cyber internet. You use the field for those armed conflicts is internet rather than the battlefield we can see in the natural world. So what about the cyber warfare? Cyber warfare is another term. There are so many terms that confuse and make the international community make it hard, difficult for the states, especially those power states, to sit down to have the consensus how to regulate the use of force by the state in the internet. So to me, the cyber warfare is rhetoric. It's not for the purpose of prescribe. It's only descriptive. It's not for the purpose to maintain any activity. The reason why is after the end of World War II, actually there is no war that has been declared by any state. There is only war or armed conflict without declaration. So we can find the international law documents after 1945 replace the word warfare by armed conflict, which is a situation, which is a condition, which is that means a state or armed group, they resort to violence instantly, continuously. That is a condition, and we call it armed conflict. in the case when we call it armed conflict rather than war, we can find more international normative framework to regulate those state acts. Next, please. So my personal opinion is that there are a lot of cyber activities. The cyber attack regarding the use of force is a core part. However, the yellow circle, the red circle, and the blue circle, they are overlapped, as you can see from my slide. But the cyber attack is only the part, only those activities that regarding the state act on the use of force. Next, please. So, cyber crime focuses on individual responsibility, and it's a criminal act. It's about malicious, and it's most important. It is disruption. It's not a destruction. It's disruption. It makes you feel inconvenient, but it's not destruction. And in that case, since it's a crime, it is a law enforcement act. And then we have to look into whether the law enforcement is qualified as under the criminal law. And then we have to see whether it is fits the Convention of Cybercrime. Next, please. And cyber attack, cyber operations, or warfares focus on state responsibility rather than individual responsibility. So in that case, we focus on the conduct of hostility. That is the method of means of warfare. And we focus on the hostile intent. And in that case, in the cyber attack, we look into, is there any destruction? Is there any physical damages to person, to property? And we apply the international law regarding use of force or armed conflict to judge those conduct, whether it's legal or illegal. And domestic law, we will have to look into, is there any rules of engagement in that country regarding how to use force in the internet? And lastly, we will see whether the use of force can be justified by the United Nations Charters or Geneva Convention. Next, please. So, since we mentioned about the United Nations Charter, Article 1, the purpose of the United Nations is to maintain international peace and security. And Article 2, Paragraph 4, it's a non-use of force principle. It says that all members should refrain from, in their international relations, from the threat or use of force. And Article 51 is prescribed. It prescribes the state still have their inherent right of self-defense. Next, please. Next. Okay, so, yeah, please, this one. This slide is, I analyzed the United Nations Charters, Article 2, Paragraph 4, and Article 51. According to Article 2, Paragraph 4, states should refrain from use of force, which means use of force is prohibited in international relationship. But Article 51 also mentioned that when the state is attacked by the force, if they are attacked by the armed attack, they can claim their inherent right of self-defense. So, to me, from the perspective of internet or cyberspace activities, the interesting thing is, can we, or by what way should we analyze the use of the cyber attack or cyber operation as a kind of use of force or as a kind of armed attack, so that the victim state can claim their inherent right of self-defense. Next, please. So, as Professor Xi has mentioned that there are many incidents already happened. It looks like cyber attack or cyber war. However, I have to report to everybody here, there is no, so far there is no state claims that my government is responsible for that cyber attack. There is only terrorist group claim that we are responsible for that cyber attack. And so far there is no people really died from cyber attack. There is some kind of destruction, and even in the case of Estonia, it's a kind of disruption, inconvenience, rather than any destruction. There was destruction, but it's only destruction of data. So it raised an issue whether destruction of data or attack on the critical infrastructure is a kind of use of force. Is it a kind of cyber attack? And so that we can discuss whether it raised to the degree, to the threat as an armed attack, and the victim state can claim their right of self-defense. Next, please. Next. Okay, stop here. So I think my time is up. According to Telemenu 2.0, those experts propose 8 non-exclusive the factors to determine whether an act by the state in the internet, whether those activities reach the threshold of the use of force or reach the state threshold of armed attack. They are non-exclusive. The first one is the immediacy and directiveness and invasiveness and the measurable of effect and the military character and the state involvement and presumptive of legality. So I know there are a lot of issues, and we should have another time to discuss more. And lastly, I would like to say, as just Professor Xi just mentioned, there is a resolution proposed, but however it fails because of lack of representatives. I think not until the day that the power states jumped into the floor debate to declare their policy, their secrecy of how they engaged in the internet by the state, there won't be any consensus, because the activities in the internet is always secret. And so I think if we can come to a conclusion, come to a consensus, it's a good start. At least we can, it will not go into solve every problem, but it will be a good start to reach the consensus by the international community. Thank you.
Thank you, Professor Tian. It is interesting to know from his presentation that there's no war declared after World War II, but there's still a lot of armed conflicts. And we hope there's no war in the future because of some internet conflicts. Okay, let's go to the next and the last. Nicole.
Okay. Our moderator, Judge Henry Tsai, and the distinguished panelist, Professor Milton Muller, whom we met last year in Montreal, and Professor Xi and Professor Tian, and our distinguished guest in the Zhonghua Telecom building and online. I must echo Professor Muller first in the very beginning. When we talk about this topic, we must think about the essence of the internet and the cyberspace. And I totally agree that the cyberspace is a shared global property. So the previous one, I need to mention my topic. Previous one. Okay, so now I'm going to use 10 minutes to talk about the internet jurisdiction, emerging issues, and the way forward. Okay, next. Yeah, including the introduction, some cases, and the issues raised, and the proposals, and the way forward. Next. As we all know that the cyberspace, the internet developed so quickly and to an unexpected extent for the time being. So in the past, the previous decades, the internet development focused on the infrastructure, including the interconnection, exchange, and some other technical issues. And the last decade, the internet development and the internet community focused on the issues concerning about technical innovations, especially not only limited to the communication technology, but also I think the information technology. So that so-called ICT technology. But right now, not yet. Okay, thank you. And I think from recent years and to next decade, I think the policy, regulations, and the governance will be the core issues about concerning about the cyberspace. Yeah, next. Okay, so the internet is transnational, while legal system remain based on territoriality and separate jurisdiction. So that is the big issue. Next. When we do business, when our normal life and even also include the government administration, also on the internet. So we can see there are so many different how can I say, different parts usage about the internet, on the internet, including the global digital economy, and like a professor, she mentioned the internet human rights, and the Professor Tan mentioned the cybersecurity. So do we need transnational legal frameworks? I think transnational legal frameworks demands, we need the legal frameworks that are as transnational as internet itself. Is it possible? Next. So we can, I can raise some cases. The first case is about the cybercrime case, the Pirate Bay. I think the friends from internet community are familiar with this case. The Pirate Bay online is starting its business from 2003, and the two domains seized by Swedish court in 2015. Those two domains are piratebay.se, the piratebay.se, but only two domains seized by Swedish court. There are other 6 domains expanded, include piratebay.gs, piratebay.la, piratebay.vg, piratebay.am, piratebay.mn, piratebay.gd. So the expanded domains are outside the jurisdiction of Sweden. Next. The other cybercrime case, online activities and the data locations. The controversial tweets were made by someone in US. Let's take the example, which is also where Twitter and its servers are located. In the US, hate speech is protected by the constitutional law under the freedom of speech. But in France, in some European countries, hate speech is illegal. Yeah. So consider the far-reaching impacts of this attempt to regulate internet and the social media speech. Do laws of one country apply to a company based in another country whose laws differ? Can a nation never or ever have global jurisdiction over speech on the internet? Next. Oh, this is an interesting case. Cybercrime. First, space crime. Astronaut Anne McLean is facing the first allegation of a crime committed in space. McLean's estranged wife, Summer Warden, asked her bank about the locations of the devices that had used her login information to recently access her account. She reportedly found that one computer network used was registered to the NASA. Warden accused Anne McLean of accessing her bank account while on a 6-month mission aboard the International Space Station. So, how about the jurisdiction? Next. There are so many cases: business registration, multiple layers of resistance. One company, its servers, business, and operators are from or registered in different countries. Next. Another case, US embargo against Cuba. Steve Marshall is a British travel agent. He lives in Spain, and he sells trips to Europeans who want to go to sunny places, including Cuba. In October some year, about 80 of his websites stopped working because of the US government. The sites in English, French, and Spanish had been online since 1998. Some, like CubaHemingway.com, were literary. Others discussed Cuba history and culture, like CubaHavanaCity.com. Still others, different websites were purely commercial sites aimed at Italian and French tourists. So that is a British citizen living in Spain with internet services in the Bahamas, selling trips to Europeans who want to go to Cuba, and having his domain name suspended by his US register because it breaks the US embargo against Cuba. So complicated, right? Next. Another case is about China, as Dr. Muller mentioned. China, just like internet. China internet entire structure is very much akin to a corporate internet with these advantages. First, China can impose its internet censorship program. Second, China can disconnect from the internet whenever it detects an external attack, but still maintain a level of internet connectivity within its borders. Third, domestic traffic never leaves the country's borders. Next. So, as the cases mentioned above, no one-size-fits-all solution. Internet is a cross-border communications media with no single authority governing it. Disputes between countries with different laws often arise. Different countries have different policies and internet regulation. Existing remedies for resolving international conflicts of law are inadequate for the internet. No one-size-fits-all solution for near 200 countries. Courts have long recognized, I think Judge Tai, have noticed that for a long time. Long recognized these issues, but there has been little progress made toward finding a solution to the internet jurisdiction dilemma. As Professor Xu mentioned, the UNGGE has failed, but I think many experts from the legal field has also tried their best to find a solution. Next. So what is the consequence? The economy suffers as businesses are less likely to invest and innovate due to legal uncertainties. E-commerce wastes valuable resources handling international legal disputes. Users may find themselves facing legal claims for activities that are legal in the user's country, in different countries. I think especially during or after the COVID-19 period, many activities, including the enterprise, the private sector's activities and even the government activities, go online. So I think we can see the consequence: less investment, the international legal disputes, and uncertain legal claims. So there will be huge economic impact. Next. So even within the same country, there are sometimes disagreements about internet jurisdiction. Two California judges in the same district disagreed about their jurisdictional competence to hear cases between Korea plaintiff and Australia defendant who used US social media platforms. Complex again. Next. There is another issue, I think Professor Chen mentioned, relating to the international jurisdiction. That's a law enforcement issue. So although right now, not only the international jurisdiction issues is not so clear, but also the law enforcement issue. So, so I mentioned about the domain name abuse effort of ICANN. The technical abuse is more clear than others. The CCT review team mentioned that the internationally deceptive conniving or unsolicited activities that actively make use of the DNS and or the procedures used to register domain names. Next. We can see the principle of proportionality of a DNS regime. The technical abuse is the higher proportionality. But how about the abuse of content? Maybe we can think about how to leverage or use or learn from the principle of the internet community to balance the technical abuse of domain name. Next. So the trend of domain name abuse, scholars research policy tendencies from intermediary liability to intermediary responsibility. Under the contracts between registrar, and the registrant, registries have flexibility to terminate the DNS service with a registrant for technical or content abuse. So right now, I think the TWIGF has made its efforts to coordinate with the ISP, the operators, to discuss about the norms or other possible approach for the from another point of view to solve the issues raised by the international jurisdiction. So under local laws, service providers have different approaches in responsible to local law requirements. Next. How many minutes? Oh, I cover 3 minutes. Okay. So access to 21st century technology at a very low to no cost. So right now, both technical tools and the legal tools have to be updated for the policies and national security agencies to keep us safe in the context. Next. So the next few pages, I think our friends has already being familiar with. So that is a characteristic internet policy development. You can see the multiple stakeholder, the bottom of model, the standard setting, other different characteristic from ICANN, ITU, IGF, EPNIC, IET, and Nato. Okay, next. So global ecology of choices for internet governance. Right now, I think we are on the way of multiple stakeholder internet governance. Next. So courts have struggled to develop the satisfactory solution, yet no progress has been made toward a uniform global standard of internet jurisdiction. So some proposals have been made. Next. Including the universal regulatory scheme, a global standard for determining jurisdiction, and just filtering or choice of laws provision. Next. So, way forward. The best model for internet governance may be a hybrid that incorporates some elements from multiple models. Internet governance is a complex task requiring a complex set of regulatory mechanisms. Next. Okay, that's my presentation. Thank you.
Nicole, thank you for your presentation. I'm glad that you introduced a lot of cases and raised a lot of issues. And one of the cases even brings us to another level, mix up of the problem with internet and even to the outer space. Okay. And I'm so glad that you also mentioned about the issue in the court. Okay. Actually, there are a lot of cases coming to the court because of the disinformation. Mm-hmm. Okay.
The one point I want to mention that I usually encourage our internet users to raise the cases to the court. Yeah, because we need the court to make the decision that is what we can push or make the law enforcement and the law improvement. That's very important. Yeah, that's my point.
Very welcome. I'm here waiting for all of you. Okay. I'm sorry that my time controlling is not so good. So is there any question here for our special speakers? Yeah? Muller, do you want to say something to us? Or some response?
I'm sorry, I couldn't hear the question.
Do you have something to share with us or any response to all the panelists?
Are you asking me?
Yes.
Okay. It was, the sound was breaking up a little bit, and I couldn't tell if you were asking somebody in the audience there or you're asking me. Yeah, there's one thing I do want to say, and when you talk about rules and about governance, sometimes you may be looking in the wrong place. So there are many rules that govern the internet that are not coming from traditional courts or treaties. For example, most of the rules of cyberspace are set by protocols, by standards, and by the operators. So you think about how routing works, right? There's a protocol called BGP, and that governs the way packets go from their origin to their destination. So we don't need a treaty. We don't need governments to sit in a room and sign contracts or documents. It's all worked out in the private sector by the internet service providers and by the standards and the protocols. And think about things like how we handle spam filters or how we handle phishing. Most of the work is actually done by the operators who are detecting abuse and spam, and they're intercepting it or filtering it out in their service. So don't think that all of the rules that govern cyberspace have to be coming from courts and traditional law.
Okay, thank you, Professor Muller. And talking about the rules out of the court and or the law, I would like to ask Professor Muller a question. That since the root A is located in the States, what is the standing of the United States government? Does the United States government still think that the root A is the property of United States? Because I think the root A have a very big controlling power to the whole internet.
Right. So that's a very important question. So you know about the transition, the IANA transition that happened in 2016?
Yes. But I mean the physical root A, not the power to edit the content, but the physical property.
Right, but the location, there's no root, there's no a root server. There's a master file, the root zone file, and the authority over that is held by ICANN, and the implementation of it is by VeriSign, which is in the United States. However, after the IANA transition, they are under contract to ICANN to implement the root zone file that ICANN gives them.
Okay, so we can say that international community now can claim the property of root A. Can we say that?
We can. Well, I'm a little bit reluctant to call the root zone a property. I would call the control of the root zone file's contents is definitely controlled by the international community. Yes.
Okay. Thank you so much. Okay, I think time is up. Would you want to make a conclusion? Or let's just end it. Okay, so I declare that we end up our session. Thank you so much for your joining. Thank you so much.